I am going to start by calling the docket. When I call your case, if you would introduce yourself, let me know the total amount of time you need for the hearing, and that is the presentation by both sides, and finally, whether you need a record or not. First up, we have Barber versus Carroll.
Good morning, Your Honor. Lauren Spencer for the plaintiffs. We have 3 pending motions. One will be very short. I imagine 30 to 45 minutes.
Good morning, Your Honor. Walker Bauer here for Defendant Carroll. If the court's taking up all 3 motions, I would announce an hour.
Total?
Yes, Your Honor.
Okay, and do y'all need...
As for record, Your Honor, for the summary judgment, I don't need a record. For the motions to strike, I would request a record.
Great, thank you. And next up, we have Harris and Nelson versus Chavez. Anybody here on that one? Okay. And then next up, we have Mendez versus O'Connell.
Yeah, good morning, Your Honor. Colton Smith for the plaintiff, and I'm going to suspect, my guess, and Ms. Wilson can give you her opinion, 30 minutes total.
All right. Good morning, Your Honor. Lily Wilson for Defendant Daniel O'Connell, and I agree that 30 minutes total should be fine.
And anybody need a record on that one?
No, Your Honor.
Okay. And y'all have already conferred about the issues, I hope?
Yes.
Yes, Your Honor.
Okay, fair enough. Great. All right, then we are going to take up the cases in that order. So we will start with Barber versus Carroll. Counsel, are we going to take up the expert motions first?
Your Honor, I think it would be prudent for time's sake to take up the motion for summary judgment because, again, I believe it'll be fairly short.
Okay, well,
I have no preference, Your Honor. I'm responding in both motions.
Okay.
Or all 3 motions, forgive me.
All right, Ms. Simon, you can hold off and we'll get you back when we are ready to go to the motions to strike. And for the folks here on the other case, you're welcome to turn off your video until I call you back. All right. We will get to you as soon as we can. All right. And let's see. I'm trying to think. Were their plaintiff's motions to strike, right?
That's right, Your Honor.
Okay. You may proceed.
Thank you. And just a little background, Your Honor. This is a case stemming from a motor vehicle collision that occurred back in February of 2022. Without getting into the real meat of it, plaintiffs were headed southbound on 183, defendant heading northbound. They reach an intersection and defendant is intending to go left while plaintiffs intend to go straight. Vehicles were damaged and plaintiffs have asserted personal injury claims against the defendant. Plaintiff brought forth this motion for a summary judgment based on 3 affirmative defenses raised by the defense: contributory negligence, sudden emergency, and unavoidable accident. The last 2 are tied in together. On contributory negligence, Your Honor, defendant is disputing liability. Ultimately, plaintiff is not going to address it and will drop that part of the motion. We'll argue that point at trial. What would be left would be just that to address the sudden emergency and the unavoidable accident. These, the case law categorizes these as affirmative defenses in one portion of the law, in another inferential rebuttal defenses. Even if it is an inferential rebuttal defense, Your Honor, the defendant still needs to put forth evidence of those defenses. Essentially, it's defendant making an argument of plaintiff, you have your facts wrong. My negligence had nothing to do with this accident. And so ultimately, inclusion of any sudden emergency or unavoidable accident needs evidence to support it if it's going to be given as an instruction to any jury. No evidence has been put forth by defendant, nor did defendant address these points in the response to my motion. As such, plaintiff respectfully requests that this court grant plaintiff's no evidence motion for summary judgment in part on sudden emergency and unavoidable accident. Thank you.
Okay, Mr. Bauer?
Thank you, Your Honor. I was not aware that the comparative negligence would be dropped this morning, so just for sake of clarity, I would still ask the court to deny the motion for summary judgment as it relates to comparative negligence, as plaintiff has indicated, dropping that part of her motion. As it relates to the inferential rebuttal defenses of sudden emergency or unavoidable accident, Your Honor, I think the law is crystal clear. Those are inferential rebuttal defenses. They are instructions that go into a jury charge if the evidence supports it. And so any argument related to those inferential rebuttal defenses is more appropriately taken up at the charge conference, Your Honor, once some evidence has come in and the court is able to see the totality of what this jury charge is actually going to look like. As far as presenting some evidence, Your Honor, into those inferential rebuttal defenses, our standard in surviving summary judgment is to produce just more than a scintilla of evidence. We have attached Ms. Barber's deposition transcript, Your Honor, and in that transcript, part of what she's talking about is a 18-wheeler that was turning in front of my client, Ms. Carroll. There's some dispute there as to whether there was an 18-wheeler at the time of the when my client was turning. Ms. Barber, one of the plaintiffs, says that there was. I believe that brings enough more than a scintilla of evidence to show that there may have been a obstruction to view of people. Both parties have said they didn't see the other party until right before the accident. There's this 18-wheeler somewhere in the intersection, according to the plaintiffs. And so again, Your Honor, I think that raises more than a scintilla of evidence to survive summary judgment. And given that these are inferential rebuttal defenses, this argument is more appropriately taken up at the charge conference. And so I would ask that the entirety of plaintiff's motion be denied.
All right, Ms. Spencer, anything else on the summary judgment?
Your Honor, just briefly on the inferential rebuttals, again, within the meat of defense counsel's motion, these inferential rebuttals were not argued whatsoever. And in terms of the case law, there have been examples of sudden emergency like that of a driver having a stroke or having some traffic obstructions. Defendant testified that she did not have anything obstructing her view of the plaintiffs. Though she did not see them immediately prior to the collision, does not go properly under that of a rebuttal defense of the way of sudden emergency or an avoidable accident. These are things that are not preventable through due care, like weather, animal encounters, things like that. No such evidence exists. As such, plaintiff just continues to seek summary judgment on those particular defenses. Thank you.
Okay, I'll take it under advisement. I'm going to look at what is in the record before I give you a decision. So I'll take a little bit of time to study that. Let's go ahead and get Ms. Simon back so we can go on the record with reference to the expert. 059 Barber versus Carroll. Go ahead and state your appearances.
Good morning, Lauren Spencer with Sandoval and James for the plaintiffs, the Barber family.
And Walker Bauer here on behalf of defendant Lene Carroll.
All right, these are also plaintiff's motions. So Ms. Spencer, you may proceed.
Judge Mangrum, thank you. I've brought forth the second set of these motions today to exclude a couple of defendants' experts, one being Dr. Lesko, who is a chiropractor, and the other Dr. Jones, who is a radiologist. I will start with that of the motion to exclude Dr. Lesko. As the court knows, admissibility of an expert testimony includes an inquiry into the skill, knowledge, expertise, education, and training of this expert, but also their methodology and how they arrive at their opinions using reliable data. Credentials alone are not enough. First, plaintiff requests that it be made clear that Dr. Lesko cannot opine on the medical necessity or reasonableness of any other medical provider's bills outside of the chiropractic care, on his own admission that he is not qualified to opine on anyone else's. I doubt that's going to be an issue with Mr. Bauer and the defense. Ultimately, I'm hoping to just make that crystal clear. The second argument, and equally as important though, is that of Dr. Lesko's methodology. He testified to solely relying on a database called Context for Healthcare, C4H for short is what I'll use, to make his opinions on the reasonableness of the cost of plaintiff's expenses with the chiropractor treatment. Ultimately, plaintiff used a recent case out of Fort Worth as an example, and it's called Countryman versus Germania, where it was actually the plaintiff's expert doctor coming forth trying to use C4H to prove up the reasonableness of future care. And he used a particular benchmark in that case, did not explain why he used that benchmark, did not explain why he used C4H. And as such, the court said, look, I know there isn't magic language that you need to use, but there needs to be enough information for a jury to conclude one way or another whether this future care is going to be reasonable. Very much like that case, Dr. Lesko is using C4H and a 75th percentile benchmarker to determine this reasonableness of the plaintiff's bills. Now, there is no explanation why he uses a 75th percentile. Simply that he uses it himself. This leaves gaps in his analysis as to how he arrives at these opinions. The jury doesn't know why he's using the 75th. Why is 75 more important than using 80, 90, 60 for that matter? We don't know. C4H is a compiled database of billing data, but ultimately, Dr. Lesko is bringing forth his credentials and his subjective opinion on using the 75th benchmarker, and it's no assistance to the jury. So ultimately, plaintiff is moving to exclude this expert from offering any opinion as to plaintiff's chiropractic care and billing practices. And again, just to clarify, he's not opining on any other medical providers. Thank you.
Mr. Bauer.
Thank you, Your Honor. As it pertains to Dr. Lesko, the defendant retained Dr. Lesko and designated him as an expert to talk about the reasonable and necessity of certain medical care plaintiffs received after the car accident, namely the reasonableness of charges as it relates to chiropractic care and the necessity of some diagnostic imaging that plaintiffs received from while undergoing their chiropractic care. But that diagnostic imaging was MRIs at a different facility, but it was during the same time as the chiropractic care. And so as it relates to our designation, the deadline to designate experts has passed. That's what we designated him for. I think it's unnecessary and improper to enter an order basically reaffirming what the designation is and stating that he can't testify outside of that. That's something that if he does that at trial, obviously an objection can be made. But there's no basis for a party coming forward and saying this is what they've designated for, and judge, please enter an order saying that he can't talk about anything else. Obviously, if it's outside the designation, he can't talk about it because the designation deadline has already passed. However, as it relates, Your Honor, just to what he has opined on, Dr. Lesko, and this is in our response, all his CV and deposition testimony are attached to our response. I'm not sure if it was filed on Friday, so I'm not sure if the court has it yet, if it's been accepted, but it will be shortly. If not, I'm sure. But for the court's information, Dr. Lesko has been a doctor of chiropractic care, practicing. He's been licensed since 1987. He's been practicing in Austin since 1992, and he testified that he's run his own clinics. He's been in chiropractic care for obviously more than 30 years. And he did not just rely on C4H for his opinions, although that was a large part of what he used to come up with his opinions. He testified that he also used his education, his background, his knowledge as a 30-year practicing chiropractor to come up with the opinions as it relates to reasonableness and necessity of plaintiff's care after the accident. As your honor is aware, Rule 702 requires experts to be qualified by either knowledge, skill, experience, training, or education. They have to be qualified, and their testimony has to be relevant and based on reliable foundation. And so, I think a brief review of Dr. Lesko's CV, your honor, shows he's more than qualified as an expert as it relates to chiropractic care and things that go along with chiropractic care, such as diagnostic imaging. He's practiced as a chiropractor in Austin for more than 30 years. He bills for these same services. He knows what the standards are for these for documentation as it relates to chiropractic services. And he testified that he himself sets his own rates at his private clinic using C4H, Context for Healthcare. And he explained a little bit about what Context for Healthcare is, your honor. It's a database that amasses hundreds of thousands of charges throughout the United States that show the reasonable and the reasonable and customary charges associated with various procedures. And then you can go on their database, type in zip codes or areas, and it shows, different percentiles as to what other providers are charging. He uses that in coming up with his own billing. He uses the 75th percentile. And he went further in his deposition, your honor, and testified why he doesn't go to the 90th percentile is because you have to be extremely qualified with some specialized training in order to go up and justify going to the 90th percentile. That was all in his deposition testimony, your honor. So I think it's a bit of a mischaracterization to say he just randomly picked 75% and only used C4H to come up with his opinions. He also testified as to why he found some treatment unsupported and why he put 0 for a charge. And it was because the documentation in the records did not rise to the standard that is required of chiropractors in the state of Texas. And so he went through all of that. Again, he used his knowledge, his skill, his experience, and his own practice of over 30 years as a chiropractor, along with the C4H, to come up with that database, or to come up with his opinions in this case, your honor. Further, as it just relates to C4H, because I think that's the real point and argument here. Plaintiff's own expert in their designation cited to the C4H and called it a, quote, trusted source for healthcare data offering solutions that include fee schedules, claims editing, and compliance tools. Plaintiff's expert goes on that says this database is essential for establishing fair and competitive charge rates. So I think everybody's experts here agree that the C4H is an important tool that shows good information, trusted source of healthcare data that can be used to come up with the opinions that are relevant to this case. This is a car wreck case with claims of bodily injury, your honor. Plaintiffs have the burden of proving that their care was both necessary and that the charges they were billed were reasonable. That's what Dr. Lesko is testifying about in this case, and he's using both his knowledge, skill, and experience, and the database that everybody says is a trusted source to come up with his opinions in this case. And for that reason, he should be allowed to testify. He should not be excluded from evidence. And I agree with Ms. Spencer of what we've designated him to do. We don't anticipate him to testify about anything else. But I don't think that an order clarifying that is necessary.
Okay. Ms. Spencer, you have the final word.
Thank you, Your Honor. Ultimately, Dr. Lesko indicating that he used his knowledge, expertise, skill, etc., is not enough without answering why. You know, why it is that you're using this particular benchmarker in C4H. Though our expert, plaintiff's expert, is not up for discussion today, ultimately, it was one of the items that he lists in terms of coming up with his opinions in the case, but it is not the sole item. Again, credentials alone, Dr. Lesko being that of a chiropractor for 30 years, it's not enough. Rule 702 is very clear. Dalbert Robinson and its progeny are very clear that it is simply not enough to reach the opinions without a proper methodology. And these gaps in the analysis are insufficient, and it's going to hurt the jury's understanding of what it is that he's there for. Thank you.
Okay. Let's go ahead and argue the second motion. I'm going to take these all under advisement. Thank you.
Thank you, Your Honor. As to defendant's expert, Dr. Jones, he is a radiologist operating out of Houston. The argument in terms of the methodology, they're rather similar. However, I'm going to tackle his qualifications first. This is a radiologist practicing out of Houston. He agreed and testified to never working in a personal injury setting before, which is different from that of Dr. Lesko. He actually has, but he's never worked in a personal injury setting. Dr. Jones has never billed in a personal injury setting, and he has never practiced in the greater Austin area in that of Travis County. His expertise stems from billing patients who pay out of pocket or under commercial payers like that of health insurance. However, a letter of protection or an LOP is foreign to him, and he agreed to that and testified to it. Just because he is a radiologist, it does not, again, make it enough for him to opine on every medical related issue. This is a matter in a personal injury setting with a letter of protection in place as to the billing of this particular radiologist who did the MRIs on 2 of the adult plaintiffs. And Dr. Jones holds no experience in this arena. As for his methodology, very similarly uses what his facility charges patients out of pocket. And please remember, this is not a patient who is paying out of pocket, but that of with an LOP in place. However, when looking at the doctor's facility charges online with a public charge master, which is a list of procedures and what they cost, the data does not match. There was an exhibit attached to my motion that is a screenshot of sorts with the charge master charges, for example, for an MRI. Online, it gives the patients a payment calculator, an estimator of how much they're going to pay. An MRI had a cost of $7,203, according to that charge master of Dr. Jones's facility. Dr. Jones testifies, well, when patients are paying out of pocket, they're charged $500. And it's never going to be the charge master amounts. Okay, but why? Okay, there's a gap there. Nowhere on the charge master is there a disclaimer of sorts saying you'll pay less. On the contrary, there are multiple disclaimers on there saying you might end up paying more. Doctor's explanation was just, well, it never happens. They never end up paying that amount. So then Dr. Jones goes into comparing out-of-pocket charges of his own facility and that of Longhorn Imaging's out-of-pocket charges. But he never tries to use the facility's charge masters in a payment calculator of sorts. He doesn't use any other data of other radiologists in the county. And he does not use any analysis in a personal injury context with an LOP. As such, plaintiff respectfully requests this court to exclude Dr. Jones's testimony and opinions from this case, as he is unqualified and his flawed methodology leaves two wide gaps in his analysis between the way he arrives at his opinions and his opinions. Thank you.
All right, Mr. Bauer.
Thank you, Your Honor. I will try and be brief. Like Ms. Spencer said, I think the arguments are pretty similar here, with a few additions, and obviously a change of what the expert is testifying about. Dr. Jones was retained by defendants to provide expert opinion on one thing: the reasonableness of charges as it relates to MRIs that plaintiffs received. And x-rays. So I guess I should say diagnostic imaging. I believe there was one x-ray and multiple MRIs that he provided opinions on. He did not provide opinions as to injuries, causation. The only thing he opined on were the charges associated with those diagnostic imaging and whether they were reasonable and customary in the state of Texas. As Your Honor is aware, one of the things that plaintiffs have to prove in order to recover medical costs in a personal injury case is that both their treatment was necessary and that the charges associated with said treatment were reasonable. That benchmark in the law is not made reasonable for those people providing care under an LOP or reasonable as compared to people in a personal injury lawsuit. It's reasonable for the care provided in the state of Texas. It's for everybody. And Dr. Jones testified that cash prices, in his experience, and I believe he's been a board certified radiologist for over 11 years. He's been helping set cash prices at his clinic since 2018, I believe is what he testified to, Your Honor. Those prices, it doesn't matter if the person is coming in off the street and just wants an MRI for fun, if they are being sent to them by an attorney, if they are being sent to them by another referring provider, the cash price is the same for everyone. And that's what he based his opinion on, was the information and research he did as the person in charge of setting the cash price at his own clinic. Part of that was collecting cash prices and reimbursement rates from other clinics, including the clinic that plaintiffs went to, Your Honor. He got the cash price from the imaging center plaintiffs went to, and the cash price from Longhorn Imaging was $550, which is right in the range of what Dr. Jones says is a reasonable price. I believe his opinion was that his cash price is $500. His reasonable range is between $450 and $750. That obviously, calling the place that plaintiffs went to and asking what the cash price was out of pocket, it was not given to him with a caveat of, oh, but if they come in with an LOP, it's a different cash price. It's just the cash price is $550 at the place that the plaintiffs actually went. That's not the only place he talked to. He said he did, research, reached out to other payers, looked at databases, reached out to other clinics throughout the state of Texas, and came up, saw what they were charging, what they were getting reimbursed for, and came up with what his cash price was, which he believed to be a reasonable cash price for the services that he's providing. It's the same services that he's opining on. His being in Houston, I don't think plaintiffs cited to any case law that said that a doctor in Houston is less qualified than a doctor in Austin for somebody getting treatment in Austin. Dr. Jones testified that his experience is that the prices throughout Texas are fairly similar, and in his opinion, it was probably more expensive in Houston than it was in Austin. And so I think an argument that he's disqualified from testifying in a case because he doesn't have a clinic in Austin is not supported under 702 and not supported by the facts of Dr. Jones's background. Again, he's licensed to practice medicine throughout the state of Texas. He's a board certified radiologist who helps establish the prices and the cash prices at his own clinic, and has done research throughout the state of Texas to come up with that price to be reasonable and competitive in the market in which he operates in. Further, Your Honor, as it relates to the charge master price, obviously that's something that plaintiffs and Ms. Spencer can bring up at trial if they would like to. But he testified as it wasn't just why that his testimony wasn't just, well, that's the number and I don't know why. He did explain what the charge master number was. He explained how it was used. He explained in pretty great detail that no one has ever charged that number, that it is essentially a number that has to be published and is used in negotiating prices with third-party payers, namely usually insurance companies, right? And so he did testify as to the full scope of the charge master price, but he didn't use that number in coming up with his opinions because in his own testimony, he said that's not what patients get charged, right? And so that would be a giant analytical gap. The scope of reviewing what the analytical gap is what the expert actually uses versus what his opinion is. What Dr. Jones used in coming up with his opinions was his own research and calling other facilities, including the ones plaintiff went to ask what the cash prices were throughout the state and coming up with his own cash price. And you'll see in reviewing our response with his testimony that the cash price he has and the cash price that he thinks is reasonable is right in line with what he found when doing this research with other facilities. And so respectfully, I think Dr. Jones is more than qualified to testify about the reasonableness of charges as it relates to radiological imaging, and that his methodology is not flawed. And while the jury can obviously agree to or decide to agree or disagree with his opinions shouldn't be struck just because they're adverse to plaintiff's position. So we would ask that the motion to strike be denied.
Ms. Spencer, it's your motion. You have the final say.
Thank you. And just briefly, Your Honor, part of Mr. Bauer's argument was that of plaintiffs bringing up Travis County. Ultimately, these experts are looking at what's usual, customary, and reasonable within a given county, which is why it was so important to bring that up. And Dr. Jones has not used all the factors that come into setting a price for a service into consideration. He, as Mr. Bauer indicated, you know, he's looking at out-of-pocket expenses, out-of-pocket charges for people, and he is not using a charge master in terms of, you know, a price that's negotiated with commercial payers. And yet in his opinion, in his actual report, he includes what government payers like Medicare and Medicaid charge for something, when he testified that he didn't use that. It's there as a comparison, and for what? It's not useful to the jury. Why is it there? You know, these doctors at this facility of Longhorn Imaging, you know, they are not getting paid to this point. They are the ones who inherit this risk of not getting paid. Another doctor that the defense has hired indicated these folks wait 2-3 years to get paid. These are important factors that only affect doctors and physicians and professionals in the medical field in a personal injury setting. Thank you.
Right, Ms. Spencer, let's go back. I want to make sure I understand on the summary judgment. The plaintiff is dropping their request to move forward on summary judgment as to comparative fault.
That's right, Your Honor. And I am perfectly fine with, I included some orders in the Dropbox folder that we were supposed to use last week, Word document as well, so that can be taken off, and solely looking for an order on that of sudden emergency and unavoidable accident.
Okay, well, I think Mr. Bauer was wanting the court to enter an order on that because otherwise there's nothing in the court's file to indicate that you've actually dropped that request. So I don't know, maybe I'll go ahead.
Just for clarity, that Your Honor pointed out my concern exactly. I just would like something, I suppose we're still on the record, so If with that agreement on the record, that may be enough. I just wanted something so that when we get to trial, that's not a matter that is needed to be taken up before voir dire.
Okay, well, it's something I will definitely ask that you confer about when we get to the point where we're doing orders on these motions. Okay, let's put it that way. I will make a note, a part of the docket note that plaintiff stated on the record that they are not moving forward on that basis. And but we'll get to it when we have rulings on the motions. How about that?
Understood, Your Honor.
Sounds good, Your Honor.
Okay, great. Seeing nothing else, y'all are free to exit the virtual courtroom.
Thank you, Your
Your Honor.
Thank you. Have a great week.
You too.
Take care. All right. And this one is plaintiff's motion.
That's correct, Your Honor.
Okay, you may proceed then.
So I'm going to try to do this in less than 5 minutes. First off, nothing I'm complaining about today has anything to do with Miss Wilson. I'm not calling into question anything she's done. She's been great to work with over the last 2 months, as were the 2 attorneys before her that worked on this case. This is an issue that I have with State Farm. And for whatever reason, recently, State Farm has gotten difficult on this little issue. They're difficult in a lot of ways, but this one issue is something new that's risen in a couple of cases recently, is they won't give us proof of the insurance policy or policies that were available at the time of the accident. I know that sounds crazy, but we sent a demand letter the beginning of October last year, so 8 months ago. It was for an amount that would have triggered any and all insurance policies that would have been available in this case. So that was October of last year. We filed later in October. Disclosures were due December 19th, and disclosures, they should have given us copies of the insurance policy, proof that what insurance policies may, and the word is may, cover, okay? And so December 19th rolled around. Obviously, that was right before Christmas. I wasn't going to complain about it. We didn't get any disclosures whatsoever. Beginning of January, I reached out. Hey, guys, and this was predecessor to Lily, a couple of attorneys before her. I'm like, hey, David, need to get a copy of the policy. We've gotten nothing that's been filed yet, or nothing served on us in response to disclosures. Crickets, didn't hear anything, sent several follow-up emails. Finally, he responded saying, trying to get it from the adjuster. The adjuster just hasn't given it to us. We're going to continue working on it. That was in January. We ended up filing this is an amended motion, ended up filing the original motion in January. A new attorney came online, Sean. Sean reached out. We talked about the issue. He's like, all right, well, let me get this. This is ridiculous. It's taken this long. So we then they end up responding to disclosures, but not giving us proof of the insurance policies that were in effect at the time of the accident. And there's 2 of them. There's the primary auto policy, which they've given us proof that it was in place after the accident, but not on the day of the accident, number one. And number 2, there's a $2 million umbrella policy that I've been told about for the last 5 months, maybe 6 months. And to date, I still don't have a copy of the umbrella policy, and I do not have a copy of anything that shows that what the policy limits were and that the insurance applied actually on the date of the accident. And so I took the deposition of the defendant literally two months ago today, February 14th, 2 months ago, and asked him about the insurance policy. He's like, okay, well, it's the regular auto policy is my parents', And then the umbrella policy is my parents. And we just found it. He said a couple of times in his deposition about just finding the policy. That was in February. I was like, all right, great. So somehow in the next week, I'm going to get this policy. And since then, I still don't have the policy. Now, like I said at the very beginning of this, I do not believe Miss Wilson has done anything inappropriate here. Like I said, State Farm has done this in some other cases. They've come back and said, oh, we can't give proof of insurance at an earlier time period. I'm like, sure you can, because how could you ever dispute or fight with one of your insureds about what insurance applied? You've got something that shows what insurance was applicable on the date of the accident, period. And so I'm here today to ask, I want proof of the insurance policies that were in force at the time of the accident that may, because they undoubtedly State Farm will come back and say, well, we haven't proven whether the umbrella applies or not. Well, it's been 5 months since disclosures were due. I'm entitled to that policy to take a look at it myself. So we're asking for these 2 insurance policies and really asking that State Farm provide them. Number one, pay my attorney's fees for being here so we can stop doing this in the future, because this is a ridiculous fight over insurance policy amounts on the day of an accident. So that's what I'm requesting, Judge. And just to let you know, as a final comment, we have a mediation next week. And so I've been told the insurance is available, right? That it was applied at the day of the accident, but I don't have an actual document in my hands that proves that. And I'm trying to get ready for this mediation. So I'm asking for it to be provided and to be provided within the next 7 days. Thank you, Judge.
Ms. Wilson.
Good morning, Your Honor. Mr. Smith is absolutely correct. I have done all that I can do. 3 emails, 3 phone calls at least a week. Typically they go, I don't even get a response. I did speak to the adjuster this morning. So the issue that they keep telling me exists is that the umbrella policy is in the defendant's parents' names. And then the defendant's policy is in his name with a different address as his parents' address. So I guess there does exist some question between them. I don't understand how, as you know, it is State Farm's documents, how they're not able to hop on a quick call and figure it out. This case was David's, and he's had some personal matters to take care of, and then Sean was, on it for about 2 days. But since I've had it, I have been as annoying as I can to State Farm. I mean, truly, I don't know that I could have done anything more to get this confirmation of coverage signature. I did get one document today, but again, it doesn't indicate. I mean, I'm happy to share my screen and share the document that I got this morning, but it doesn't have Daniel's name on it, the defendant's name on it. So they're still raising the same question. And that is about all I've got on this.
Okay. Well, it sounds like they may want to have a conversation sometime about whether coverage exists, or they may want to dispute it. But I think the rules of civil procedure are pretty clear about production of policies that may cover part of a judgment. I'm looking at the petition. It says in excess of $1 million. So, Ms. Wilson, why don't you tell the carrier they have 2 days to produce both the primary and the excess policy. With mediation coming up, I think it needs to be done quickly.
I agree, Your Honor.
Okay, Mr. Smith, will that cover everything that you are seeking this morning?
That'll take care of it. Thank you so much. I appreciate your time today.
Okay, fair enough. Well, if y'all could submit an order agreed as to form We will require that production by Wednesday, the 16th.
Yes,
You
Your
can
Honor.
email it to Ms. Seeger and I'll get it signed.
Will do.
Thank you, Your
so
Honor.
much.
Great. Y'all are free to go. Have a great week. Thank
You
You
you.
do the same. Thank you.
Good afternoon, everyone. Welcome to the 200th. We have a number of cases set this afternoon. I'm going to start by calling the docket. When I call your case, I need brief introductions, who you are, who you represent, the total amount of time the hearing will take, and whether you need a record or not. All right, first up, Neal versus McDonald et al.
That case passed.
Oh, sorry.
Maria Fox on behalf of Astrid Slaughter and Oncology Pharmacy Services, Inc. And I will also defer to Mr. Dow, but I don't think we would take more than 10 minutes. There are 3 minors, but I still think could move fairly quickly.
Your Honor, Luke Dow ad litem agreed 10 minutes or less. And I don't think we need a record.
All right, thank you. Next up, RPM Living versus Tides.
Good morning, this is Kathleen Mallory for RPM Living. I actually have 2 cases on the docket today. Both of them are for motions for no answer default judgment. I don't need a record. I think everything I'm going to have has been submitted to the court already electronically, and it shouldn't take more than maybe 5 or 10 minutes per case.
All right, thank you. Will take us to North Edge condominium versus Benchmark et al.
Good afternoon, Your Honor. Mike Lauder on behalf of Plaintiff North Edge Condominiums HOA. I would defer to Mr. Malou as this is his motion in terms of length of time, but I would suspect it will be pretty quick. I believe it is an agreed motion. And we do not need a record, at least for our purposes.
Your Honor, Tom Malou on behalf of West Peoples. I'm in agreement. It's simply a motion for leave to join third parties, and there's been no opposition. I think everybody's in agreement. We've submitted an order with the motion.
Miles
Okay.
Anna here on behalf of Benchmark. I will also defer to Mr. Malou. We're unopposed, so shouldn't take too long.
All right, anybody else here on that one? All
Good
right.
afternoon, Your Honor. Jessica Winfont for one of the parties, Madison City Homes, just here observing.
Okay, thank you. All right, and then last but not least, let's see. I think we have Anthony versus Brody.
Good afternoon, Your Honor. Ben Newman for the plaintiff. I suspect we'll probably need about 20 to 25 minutes. I'm not sure what the court is showing on their end, but we have a motion to strike the defense expert that is set. And then the defense also filed a motion for continuance of the trial date. And we were agreeable to having Your Honor hear that motion as well, since that trial date's coming up soon. I don't know if they formally submitted that to be heard today, but we could hammer that out, and we've already filed a response, provided our response and proposed orders, all those things. And Your Honor, we will need a record for the hearing.
All right.
Alex Sherman here on behalf of the defendant, and we are in agreement with the 20 to 25 minute assessment.
Okay, what about the trial continuance? I don't see that as being set today.
So we did file it, and I think we had contacted the clerk about that. But I think that we should be able to address that issue, and we might actually be withdrawing that, but we'll see.
Okay, well, y'all are at the end, so I guess if we have time and everybody agrees that it can be taken up, that's one thing, but I'm not actually seeing that it's set and announced for today. Okay. All right. Moving on, we're going to go back to the top of the docket, which is our Smith versus Unknown Heirs. And I don't think we need a record on this one, but if everyone else on other cases, if you wouldn't mind turning your video off until I call you back, that will help me focus on the case at hand. All right, so we have a publication motion.
Yes, we have an agreed motion for order for publication in the Marshall News Messenger for Harrison County. The ad litem attorney believes that we should file publication in the place that Mr. Moody lived prior to moving to this county.
Okay. All right. Let me take a moment. Mr. Cohen, do you want to add anything?
Well, only that the court did enter an order, I believe, authorizing publication in Harrison County in the newspaper that I identified in my motion. I'm just waiting for an affidavit of publication, and once that happens, I think I'll be able to then submit my final report to the court, which I've submitted in tentative form, assuming that I'll get an affidavit of publication forthcoming. And I assume Ms. Hamilton, I assume, would be obtaining that.
Yes, Sean. Yes, sir.
All right. Well, and looking at the court's file, it doesn't look like the order for publication has actually been signed yet. Is that your understanding, Ms. Hamilton?
Yes, it's my understanding it hasn't been signed by the court.
Okay. And did y'all use the submission docket at all, or you just decided to set it for a hearing? Or
we tried the submission docket, but something failed on that end, so we decided to set it for hearing. Can you hear me, Your Honor?
yes, I can. Sorry, I'm just looking at the file here. Okay. Give me just a moment here. All right, so the motion is granted. I will get the order signed. Ms. Hamilton, do you know whether the order has been emailed to Ms. Seeger and my staff?
I do not think it has been emailed over to you guys.
If you could email it to her, she provided you the Zoom link, so you should have that handy.
Yes,
we'll
Your
get it. All right. Thank you.
All right.
You're free to go.
All right. Thank you, Your Honor.
Thank you,
Best
Your
of
Honor.
luck. And I think we decided on no record.
Correct.
Yes, Your Honor, no record needed.
All right. Who wants to take the lead?
I'm happy to, Your Honor. Just to give you a little bit of background, and then I'll call Ms. Velasquez. This is a car wreck, happened on August 18th of 23. Ms. Velasquez and her 3 minor children were involved in an accident in Pflugerville. The kids' injuries and treatment, all very similar, neck, back, shoulder type injuries. They all went to Kit Chiropractic and with soft tissue complaints. They also went to Dell. And all of the kids, from my understanding, reviewing the records and then visiting with mom, is that all the minors are doing well now. They're fully recovered. The settlements, there were multiple claimants. None of the settlements are net enough for structures, so all of the funds are being placed into the registry of the court into interest-bearing accounts with the court's approval. So unless you have questions for me, I would call Claudia Velasquez for some questions.
Ms. Velasquez, raise your right hand, please. Go ahead.
Thank you. Ma'am, will you state your name, please?
Claudia Velasquez.
And Ms. Velasquez, you are the mother of Nathan, Andres, and Luis, correct?
Correct, yes.
All right. And all of y'all were involved in an accident on August the 18th, 2023, up in Pflugerville, correct?
Correct, yes.
My understanding is that y'all were eastbound on West Pflugerville Parkway. The defendant was northbound on Cranston and tried to make a left turn in front of y'all.
Yes.
And that's how the collision happened.
Yes.
Okay. Now, all three of your children sustained some level of injury. Is that fair?
Yes.
Okay, let's talk about Nathan. He was taken by EMS to Dell Children's, correct?
Yes.
And he had complaints of face pain and neck pain, correct?
Yes.
He was discharged and followed up at KIT Chiropractic.
Yes.
And he got some chiropractic treatment, and my understanding is has made a full recovery and is doing fine.
Yes.
Okay. And if my math is correct, he is 14 and will be 15 in June.
Nathan?
Yes. I'm sorry. Oh, 2020. He's 4.
Yes.
He'll be 5 in June.
Yes.
Okay. You settled his case for $7,250. Is that correct?
Correct.
And after the deduction of attorney's fees and reduced medicals, Nathan's net recovery is $3,215.11.
Yes.
Okay. Andres was taken by EMS to Dell, correct?
Yes.
And he had neck pain as well as pain in his forearms.
Yes, correct.
Okay. He also followed up at KIT Chiropractic and is doing fine now.
Yes.
Okay. And you settled his case as well for $7,250.
Yes.
All right. And after the deduction of fees, case expenses, and reduced medicals, the net to Andres will be $3,421.34. Is that correct?
Correct.
And he is 9 years old
Yes, correct.
and will turn 10 in October.
Correct.
All right. And lastly, Luis was taken also EMS to Dell Children's. He had complaints of face pain, head pain, and left forearm pain. Is that correct?
Correct. Correct.
He was discharged and also followed up at KIT Chiropractic.
Correct.
And my understanding is that he's made a full recovery as well.
Correct.
Okay. And he just turned 12 in March, correct?
Correct.
All right. Now you settled his case for $12,000. Is that fair or is that accurate?
Yes, accurate. Yeah.
And after the deduction of fees, expenses, and reduced medicals, the net to Luis is $5,612.80. Is that correct?
Correct.
You understand that if this is approved this afternoon, the net amounts for the 3 children will be placed into the registry of the court for your kids, correct?
Correct.
And the funds will earn interest, and then as each of them turn 18, they'll be able to get their money out, plus whatever interest has been accrued in the meantime.
Correct. Yeah.
Okay. You also understand you don't have to do this. You could say no to these settlement offers and go to trial instead, right?
Correct.
And it's possible that 1, 2, or even all 3 of the kids might do better with a jury, meaning they might be awarded more money. You understand?
Correct. Yeah.
But they might be awarded less than that, or even something, or even nothing, correct?
Yeah.
After weighing those options, you've made the decision that settlement, as per the terms that we talked about, is in their best interest.
Yes.
And you understand that if Judge Mangrum approves this, neither you nor the children can come back against these named defendants or their insurance carrier for any more money from this accident.
Yes, I understand.
You're comfortable with that? You still think it's in the kid's best interest to settle?
Yes.
Okay. And you're asking the court to approve this?
Yes.
Ms. Velasquez, thank you. I'll pass the witness, Your Honor.
Your Honor, no further questions this time from.
Okay, Ms. Fox?
No questions, Your Honor. I think Mr. Dow covered everything.
Okay. Mr. Vasconcelos, what are you, as far as attorney's fees, are those a third of the value of the settlement in this case, or can you characterize that for the court?
Yes, Your Honor. We are requesting a third of the attorney's fees for the settlement plus the expenses to prosecute the case, and the expenses were to get the records and everything else.
Okay. And Mr. Dow, has the defendant agreed to pay your fee as guardian ad litem?
They have, Your Honor. And just to note, actually on Nathan and Andres, the attorney's fees are just a little bit under a third. Luis's is 1/3. And yes, that agreement is in place and I believe appears in the agreed final judgment, which was sent to y'all this afternoon. And it's $2,500 over and above the settlements. That does not come out of the kids' funds.
And we have agreed to that, Your Honor.
Okay, great. Let me just give me a moment.
It was filed at 1:45.
Was it emailed to Ms. Seeger today?
If she's 455 submission, yes.
Nope.
Oh.
Your Honor,
okay.
I can handle that. I can send that to Ms. Seeger. I'm happy to.
Okay, that'd be great. Yes. That would be helpful. I appreciate it. Okay. Ms. Velasquez, you are asking me to go ahead and approve the settlement that has been outlined by counsel today?
Yes, Your Honor.
Okay. And considering all the pros and cons of going to trial or not going to trial, you are asking the court to do this on behalf of your kids?
Yes.
Okay. All right. I am going to grant the request. The settlement is approved. And so, Mr. Dow, if you get that over to Ms. Seeger, we'll sign it.
Yes, ma'am. I'll do that right now.
All right. Y'all are free to go.
Thank you.
so much.
Appreciate
Thank
it.
you.
Thank you,
Have a
Honor.
great
Have a good
week.
day.
Take care.
Bye.
Ms. Mowry, your defaults?
Thank you, Your Honor. I have two. I don't know which one you want to hear first.
Let's see. I have Tides on McCallum South as the first one.
That's fine. So we already tendered to the court our exhibits, which just to give you the background of this case, my client is a property management company. I believe exhibit 3, it contains the agreement between my client and the defendant. I'm sorry, it's exhibit 2, which shows the obligations and duties that the owner or the defendant has to pay my client for services that are rendered. The defendant did not pay for services, and my client sent in exhibit 3 correspondence to the defendant seeking payment of fees that were outstanding and invoices. Exhibit 4 contains those invoices that were sent to the defendant that were unpaid. We filed suit on December 12 of 2024. We served the defendant with the citation and the petition on December 19, and those exhibits are attached in exhibit 1 to the motion that we filed. So we're here seeking an order of no answer default against the defendant. I also submit to the court an affidavit for attorney's fees to prepare the case, to file the petition, serve the defendant, and attend today's hearing, which I think we had it set before and it was actually canceled and rescheduled. But in any event, that affidavit that I submitted has a total cost of fees and costs of $2,710.75. So we're asking for a total judgment owed to my client to include the back owed invoices, costs, and fees of $23,729.75.
Okay, so you're saying you have submitted an attorney's fees affidavit, but it was not attached to the motion, right?
Right, it was submitted, uploaded to the court, I believe, on Friday of last week, and then emailed to the clerk as well.
You didn't ask for a record, so things that go to box go to the court reporter. If you don't have a record, they go nowhere.
Okay.
If you want me to consider awarding attorney's fees, the affidavits need to be filed with the clerk. They are not filed with the clerk as far as I can tell.
Okay.
So that's something you can accomplish after the hearing. I can take it under advisement, but right now they're not in front of the court.
Could I file the affidavit after we have an order entered on default today?
So do you not want a final default?
Well, I do. I'm concerned that this the defendant's not going to pay regardless, or we might have to negotiate if we can get anything at all. I'm not sure we're going to get our fees back anyway, so that's a realistic concern I have. I don't want to reset this hearing if I can avoid it. It's been reset once already. One of these has been. To be able to start the process of trying to collect something from this defendant. So I guess if my option is to get a hearing, an order today and not get attorney's fees, is that my option? Either that or reset the whole thing?
No, I didn't mean to suggest that. Let me back out.
Okay.
I can't give you attorney's fees right now because you haven't filed evidence of them. They're not in front of me. However, I can take the default under advisement, look at the file later this week, and if the attorney's fees are there, I can consider everything and sign an order that grants all the requested relief, including the attorney's fees. Does that
would be perfect.
Explain
Yes.
it better?
It does. Thank you.
Okay. Yeah, I did not mean to suggest another hearing or coming back would be required. I just can't sign a default until those have been filed, assuming you would like awards for those things. But go ahead.
I would. That would be my preference. Thank you.
Sure. Then why don't, after this hearing, if you could just file those 2 items, looks like there's one for each, file them and let us know that's been accomplished. Then I'll take both defaults under advisement. And let me ask, have you had any contact from this particular defendant?
I have not. We've served them the petition, we've served them all of the hearing notices. We had 2 set for one of these for hearings and then the hearing for today, and never heard a response from anyone.
Okay, fair enough. Well, like I said, I will take this one under advisement. I won't rule on it now, but if you file the attorney's fees affidavit today and let us know that has been accomplished, I will pull the file and make a ruling by the end of the week.
Okay.
All right, and you want to move on to the next one?
Correct. That would be the Tides on North Collins owner, and that would be the same situation. We'll need to take it under advisement and submit the application for attorney's fees today. Do you want me to tell you the back end of the case? I mean, the motion.
Yeah.
Okay.
And
So
just go through that service and all those items.
Sure. So this is the case, a same issue. My client is the management company, or was, for this particular defendant. Exhibit 3 is the management agreement that outlines the duties that my client had and the defendant had to my client for paying services rendered. We submitted letters to the defendant to pay invoices that were outstanding in Exhibit 4. Exhibit 5 contains the invoices that are owed of $142,434.12. Nothing was paid by the defendant. On July 11, we filed our petition against this defendant and then served the defendant on December 13 of 2024. This is the one that was rescheduled by the court, and we didn't get a hearing as early as we wanted to. The defendant never answered the complaint or the petition at any point in time or responded to me at all. So we're seeking an order my client is seeking an order for its invoices outstanding in the amount of $142,434.12. And then again, I have a fees affidavit that we will submit and file with the court today with the total fees, and that when the total amount is $2,620.27 for fees and costs incurred in that case.
Okay. Fair enough. And again, on this one, no response, no contact from the defendant whatsoever.
Correct, Your Honor.
Okay. All right. Well, Ms. Mallory, if you get those affidavits on file with the clerk and let Ms. Seeger know when that is accomplished, we'll go from there.
Wonderful. Thank you very much. I really appreciate it.
All right. You are free to exit the virtual courtroom.
Thank you.
Thanks so much. Oh. Our condo HOA case. North Edge. All right, Mr. Malou. Oh, there you are. Go ahead.
Thank you, Your Honor. This is a typical construction defect case. The condo associations filed suit against general contractor and developers. As the general contractor, we're seeking leave to join our subcontractors. There's 11 parties we're seeking to join. it's past 30 days since we answered. Obviously, we sought to do it in line with the proposed DCO, but we've had issues getting the DCO in place, so we filed the motion for leave just out of, to be safe and get it granted. So my understanding is there's no opposition to it, and we'd ask the court to grant the motion.
All right. Anyone else want to weigh in?
No objection.
All right. Plaintiff's okay with it? Anyone else?
No objections, Your Honor.
No objections, Your Honor.
All right, Mr. Malou. And let me see if I have an order. Do you know whether you submitted one to my staff?
We didn't to the staff. We did when we filed the motion, but I can resubmit. I can resubmit it to your staff if you need.
Yeah, if you would email that to Ms. Seeger, we'll get it entered. And obviously, looks like y'all have, your case is about a year old, but when you're ready for that trial setting, contact our court admin to get that on your calendar and go from there.
Thank you, Your Honor.
All right.
May I ask Ms. Seeger to put her email in the chat so I can send the order to her?
Someone in your office has it.
Okay.
She sent out the Zoom
Okay.
link, so.
I appreciate it.
Okay, great. Y'all are free to go. Have a great
Thank you,
week.
Your Honor.
Thank you, Your Honor.
We've got our motion to strike. We are going to go on the record in GN 23005861 Anthony versus Brody JTL Investments et al. Go ahead and make your appearances, counsel.
Ben Newman for the plaintiff, Your Honor.
Alex Schumer here on behalf of the defendants.
All right, and Mr. Newman, it's your motion, right?
Yes, Your Honor.
Okay, you may proceed.
Thank you, Your Honor. So we have moved to strike defense expert Dr. Kamal. He testified, or he made a controverting affidavit about the reasonableness and necessity of medical expenses. No formal report outside of that. Our reasons for moving to strike him are: one, that his controverting affidavit was served 9 months late, according to 18001, and two, Dr. Kamal did not produce, or defense counsel did not produce, any data that Dr. Kamal relies on in his opinion. And three, so he also did not, and defense counsel did not produce any information about his compensation, which is a less severe infraction, of course, than not producing the data that he relied on. And then there was an inadequate case list that was produced as well for that expert. So first, on the 1801 untimely designation issue, 18001 is a notice provision, and it says that if you're contesting the medical expenses, then you have to tell us through a controverting affidavit within 120 days after the answer is filed. And that controverting affidavit has to say, it has to be done by a qualified expert, and it has to give notice of the basis for controverting the medical expenses. So that means their deadline in this case was March 2024 to serve that affidavit on us. And they did not serve an affidavit or anything about this expert until December of 2024, which was their expert deadline. And after that point, that was about 30 days after our expert deadline. And so we did not designate a medical cost expert. We designated a life care planner. We designated our treaters. The life care planner is only testifying about future medical expenses. He's not testifying about past medical expenses. And then our treaters they're not the type of experts that go and run comps like the defense expert did in this case. They don't compare their medical costs for this treatment to others in the area, so they're not able to testify about that. And so we were not given notice that they were going to controvert the medical expenses. And then, Your Honor, probably the most important issue here is Texas Rule of Civil Procedure 195.5 says that you have to produce or make available the data that your expert relies on. And that's so that we can review that data when we're going to cross-examine that expert, and we can investigate that data to make basically to check the expert's work. To date, even after we filed this motion, they still have not provided any of these comps. And now what the expert says he relies on for his opinions are Medicare cost, insurance rates, national averages, American Society of Pain Physicians rates, and that is all the information we have for the data that they relied on. So there's no citations to where they found that data. The data itself is not provided. No website. No nothing. And so we do not have the ability to check this expert's work, and their deadline to do so was back in December. And now we're all the way here in April, and they still haven't provided it. And lastly, Your Honor, they haven't provided the fee information, which is obviously that's not as big of an infraction. The case list that they provided only has like 5 cases on it, and it's not made by the expert himself. It was sent over by the outfit called I think it's Inspe and Associates, which is the outfit that sourced Dr. Kamal to defense counsel. And so because they did not comply with Rule 195.5 or Texas Civil Practice and Remedies Code 1801, we asked that this expert be stricken in entirety.
All right, Ms. Yamron.
Yes, Your Honor. I would just like to note for the record that defendant, and I'm going to share am I allowed to share my screen, Your Honor?
You may.
Thank you. So this is directly from the court's website, which reflects that defendant filed their answer on November 6, 2023.
Well, I'm sorry. If you want me to be able to read that, you're going to need to enlarge.
Yeah, let me make it larger. I know we're all. There we go. There we go. This is a screenshot from the court's website, so this should be available to everybody.
I think you
here.
mean the clerk's website.
The clerk's website. Yep. We filed our answer on November 6, 2023. Pursuant to 18001, the plaintiff's attorney had 90 days to file affidavits in this case. So I went to this handy little date calculator on November 6, 2023. I added new dates, calculate the new date. So the plaintiff's attorney had until February 4th of 2024 to file affidavits. The plaintiff did not file his affidavits by February 4th, 2024. The first time he ever produced any affidavits to counsel was on June 6th of 2025. That is 8 months after this defendant filed their answer. And I will share my screen with you. I'll go back here. I would just like the court to take judicial notice that February 4th, 2024, and we'll be accommodating and just say February 5th, since that's a Sunday. I would just like this court to take judicial notice that 90 days after November 6th, 2023 is actually February 4th, 2024. So I'd ask the court to take that into consideration. 18001 states that the party offering the affidavit into evidence must serve a copy of the affidavit on each party to the case by the earlier of 90 days after the date the defendant files an answer. The first time plaintiff's attorney ever filed anything or provided counsel with anything bear with me a moment, was on June 4th, 2024. Now, plaintiff's attorney did file disclosures on February 13th, which again would be after the 90-day deadline. But at that time, when he filed his disclosures, he said, we will have to supplement the imaging records bills as well as the radiology. So on February 13th, he filed or not filed because he didn't actually file anything with the court, but he provided us responses to discovery, but did not actually provide any affidavits to us until June 4th of 2024. And here's what was produced on that date. And this is the first time defense counsel ever received any affidavits. So this is the first time defense counsel ever received any affidavits from the plaintiff's attorney. And I would also like to draw your attention to this affidavit. This affidavit wasn't even signed until over almost 2 weeks after the date that this was due. These affidavits are from February 13th of 2024. Now,
Okay,
plaintiffs
I don't think I can tell by looking at those.
Oh, yep.
When you got them, if that's the point you were trying to make.
Yep. So I received these on, and I can just share my email. These were received on June 4th, and I can actually zoom in. June 4th, 2024 at 11:51 p.m. This is an email.
I gotta correct this. You can see from the email that what I'm doing is forwarding these to her from a previous email that from February 13th, 2024, where you can see down at the bottom there, please find plaintiff's responses to defendant's first set of written discovery. In addition, please find our document production attached. So that was served in February of 2024. And then she emailed me and said, I don't have records. And then I forwarded that same email in June. So that's incorrect.
Okay, Your Honor, this is an email from February 13th, 2024, which is already after the 90-day deadline, by the way. And it says, please find plaintiff's responses to defendant's first set of written discovery. In addition, please find our document production attached. We will have to supplement the imaging, records and bills, as well as the radiology. None of that was produced on February 13th, 2024, which is after the deadline for the 90 days. This email, you can see it, is from June 4th, 2024. And for the first time, forwarding this response. So the first time he responded to the email about supplementing his discovery was 4 months later. This is from June 4th, 2024, and here are the attachments. These are the first time that defendant ever received these affidavits. The affidavits that were attached to these were signed by the providers a week and a half after the date that they were due. Even if we take the plaintiff's version of the story is true, their affidavits were never going to be timely. They were never going to be done within 90 days because they weren't signed until February 13th, 2024. Here is the affidavit. February 13th, 2024. Date calculator, February 4th, 2024. He did not file his affidavits timely to comply with 18001. The first time defense counsel ever received anything was 8 months after these were due.
Your Honor,
8 months. I'm not done yet.
Okay, I'm sorry.
So in order for the plaintiff to be able to get the reasonable necessity, and essentially the easier way, plaintiff's attorney has multiple options to get in testimony regarding reasonableness and necessity. He can bring in an expert to lay a foundation for that. The easiest way he could have done it was filing these affidavits within 90 days after the date the defendant filed his answer. So he didn't do that, so we can check that one off because he didn't do it. He then also has an opportunity to designate an expert to testify about that. So that is still an option that he can do if he did so properly. Now, I had an opportunity to pull up 18001 on Westlaw, and this is kind of the O'Connor's annotations and references. And I'm sure Your Honor is very well aware of In re Allstate, which is the Texas Supreme Court which says that while an uncontroverted 1801 affidavit may constitute sufficient evidence of reasonable necessity, nothing in 18001 even suggests an uncontroverted, oops, where did I go here? Oh, I don't know where I went. There we go. Oh, here we go. Nothing in 18001 even suggests an uncontroverted affidavit may be conclusive on reasonable necessity. There's no textual support for the assertion that the absence of a proper counter affidavit constitutes a basis to constrain the defendant's ability to challenge through evidence or argument the claimant's assertion that her medical expenses are reasonable in necessity. The claimant's decision to file initial affidavits may relieve her of the burden to adduce expert trial testimony on reasonableness necessity, but the opposing party's failure to serve a compliant counter affidavit has no impact on its ability to challenge reasonableness or necessity. And if we go to the case, I think that they reference Haygood in there as well. What? As the Texas Supreme Court states, 18001 is purely procedural statute that is designed to streamline proof of the reasonable necessity of the medical expenses. As we've discussed, the plaintiff attorney had the opportunity to streamline that process with affidavits. He chose not to do that. Now, we agreed, and this should be part of my response motion, to extend the expert deadlines. Now, plaintiff's attorney had an expert deadline, defendant did as well. Defendant did retain a medical expert in a timely fashion and did file that. Dr. Kamal was timely filed. Now, that is one of the that's one of the things that defendant is allowed to do. The defendant is allowed to designate an expert. That is consistent with what it says here in Ray Allstate. Defendant's allowed to do that. Now, it seems like the plaintiff's attorney doesn't have any medical bills, I guess, as we sit here to counter, but the plaintiff's life care planner, whose deposition proceeded last week, Thomas Garzillo, he relied on the charged amounts by the plaintiff's providers to estimate for future costs. The defendant is certainly allowed to respond to the plaintiff's expert. Not only did defendant file their responses timely pursuant to 18001, we're allowed to designate our own expert to testify as to reasonable and necessity. That's what the Texas Supreme Court says. That's what 18001 says. And it says in the app, even if we want to take the plaintiff's version of the story as true, which is there's just no evidence of it, in the absence of a controverting affidavit, it just allows the claimant to rely on an affidavit setting forth the necessity to avoid adducing expert testimony on those issues at trial. Defendant has made their decision. They have decided to call Dr. Kamal at trial. His deposition is actually scheduled for the 17th. And bear with me one moment. Now, moving kind of on to the 195.5, defendant timely filed their discovery responses. Bear with me a moment. This is an email from plaintiff's attorney where he is agreeing to take allowing me to take proceed with the deposition of my expert, Dr. Kamal. And the relevant portions here. You will produce all medical records for Anthony today in exchange for my agreement to do Dr. Kamal's deposition on April 17th. Plaintiff's attorney agreed to proceed with Dr. Kamal's deposition, and since then, he filed this motion saying that he is now going to be prejudiced by this deposition proceeding. Going as to the 195.5, we have timely filed his reports. We have given all the records and all the information that he is relying on in his deposition by way of document production. I can go through each one since this seems to be contentious. On that day, I did produce all of the medical records that Dr. Garzillo relied on. We have since produced an updated list with the case numbers. In his report, he documents everything that he'd relied on. We've produced his CV. We've also produced his fee schedule. This is an email I sent on Friday. And so this outlines his invoices for Dr. Kamal, for both of them. These are updated lists that go through what the cases are, where they came from. Plaintiff has been, everything that's contained in 195.5 has been produced to plaintiff's attorney. I would also like to note that plaintiff's motion is to strike him as a whole. He is a board certified pain management doctor, and there's been no evidence that there's anything that disqualifies him to provide expert opinions. He's going to be talking about causation. He's going to be talking about usual and customary charges. He's going to be talking about medical necessity. And yet plaintiff's attorney is sitting here asking you to strike him entirely. So just summarize, affidavits weren't filed timely. Defendant timely filed their expert who testifies about medical necessity and reasonableness and also causation. And all of the documents that have been requested pursuant to 195.5 have been complied with. As such, defendant would ask that this court deny the plaintiff's motion to strike.
Your Honor, may I respond to some of the allegations?
Yes.
Your Honor, I'm showing you, I'm screen sharing here with you. This is an email from me to farmers who who defense counsel is in-house for. And it's me serving TA 121 to 126. This is 6 days after the deadline to serve 18001 affidavits. Now, I'm realizing that this was 6 days late. However, the defense did not move to strike any of these 18001 affidavits. And also that doesn't change their deadline to provide them. And if to provide the controverting affidavits. And if they would have reached out to me and said, hey, you got your 18001s in a little bit late. So can we have a little bit more time to get controverting affidavits to you? That would have been no problem at all. I would have given months to do that. No problem. As long as I have adequate notice before my expert deadline that they're contesting costs, no problem. But they did not ask for that. They did not move to strike the affidavits that were produced 6 days after the deadline. And then what they did was they served their controverting affidavits 9 months late. I mean, we're talking about 6 days versus 9 months. And
Your Honor, I would just say there, right above that, it says you forwarded this message on Tuesday, June 4th, 2024. That is what it says. Right above, it says an I, the little gray dot that says you forwarded this message on Tuesday, June 4th, 2024.
Okay.
At 11:51 p.m. So just want to make sure that we're all seeing the same information.
What I'm forwarding is my email from February 13th, 2024 that has all the document production. It's me saying, hey, I sent this to you in February 13, 2024, and now I'm forwarding it to you because you're telling me you don't have it. And if we look at the PDFs themselves, TA 1 through 126, 2/13/2024. Response to defendant's written discovery, 2/13/2024. This email is from 2/13/2024. Like I forwarded this to her. This is a forwarded message of the 2/13/2024 email to Ms. Yamron. Like this email with the document production serving the affidavits according to Texas Rules of Civil Procedure 2821A is right here. It's February 13th, 2024. That's when it was served. And now to address the portion here where I say we will have to supplement some imaging records and bills. The imaging is it's like $2,000, and and we did supplement those. But even if we didn't, I mean, we'll waive $2,000 to not have to deal with this issue. But those were affidavits for the imaging that are a very, very small part of the medical expenses. But either way, it doesn't change the fact that they served theirs 9 months late. 9 months late. We served ours 6 days late, and a motion to strike our 18001 affidavits, plaintiff's 18001 affidavits, is not before the court at all. And so for that reason, the fact that we served our affidavits 6 days late doesn't change the fact that their controverting affidavits were 9 months late and grossly untimely, and after we had an opportunity to designate a cost expert. So the next thing that I want to turn to is me agreeing to the deposition date. All I'm doing, so I wasn't going to try to stop her from putting her expert on. I agreed to do his deposition this Thursday if he's still an expert in the case, of course. Like, whenever somebody asks me for dates, I'm just responding with my availability. Like, I'm not going to respond and say, no, I'm not going to agree to your expert depo because of substantive disputes that we have in the case. I was just saying that, yes, I'm available on that date, and I can do a deposition on that date. I wasn't at all waiving my right to move to strike him. I timely filed the motion to strike. And Your Honor, on the fee schedule and the case list, again, this is not that big of a deal compared to the other infractions. That email was sent by her on Friday, this past Friday. So that was 5 months after the deadline. And so I didn't realize that there were invoices in there. But if we look at the case list, there are cause numbers. We don't see where the jurisdiction is. But again, that's not as big of an infraction. The most important infraction is the Rule 195.5 infraction, which says you have to produce all of the data you're relying on. What this expert relied on was comps. He relied on insurance rates, Medicare rates, Pain Management Association rates. He just refers to them broadly, provides no citations, and despite what defense counsel says, they have not provided any of that information. They have provided none of that data. And also, as for the causation argument that defense counsel makes, all they've served is a controverting affidavit. They have not served a formal expert report. And in that controverting affidavit, there is not one opinion that says that the plaintiff's pain and impairment was not caused by the crash. That opinion is not in there. It vaguely refers to some MRI findings and says, yeah, some of these are degenerative conditions, but there's no opinion in there saying that the crash did not cause the need for medial branch blocks and radiofrequency injections, which this case is completely about. And even if it did, it wouldn't matter because he still hasn't, the expert himself has not been properly designated under Rule 95.5 because they didn't give us the data or tell us where to find it.
Okay. Your Honor, may I briefly respond? Mr. Newman seems to think that
Were
it's
you going to
my-
wait until I answered the question, or were you?
Oh, I'm sorry, Your
right
Honor. Your
on?
Honor, I apologize.
Okay. Yeah, better to wait for an answer if that's what you're after. Okay, actually, I have some questions for you, Ms. Yamron, because
Sure.
I'm a little confused about your position here. So you are arguing that because they did their Chapter 18 affidavits late, it doesn't matter that yours are 9 months late? I'm having a hard time following.
Sure, Your Honor, and I'll pull up the statute. So in order to trigger the 20 days after the defendant files the answer, the plaintiff must file theirs within the 90 days, or otherwise they essentially waive that opportunity.
Then why did you file Chapter 18 affidavits at all if the chapter wasn't triggered by the timely filing of plaintiff?
So the first time that the plaintiffs disclosed their life care planner in November, our expert deadline was in December. Their life care planner is relying on the late affidavits to calculate the futures. So for instance, the life care planner discussed the bills for the chiropractor, the bills for the imaging, the bills for future ablations and epidural steroid injections. Defendant had nothing to really counter until that point.
Okay, I guess I'm having a hard time following your logic and trying to understand why you simply didn't file a motion to strike late affidavits.
So it's not my job to strike their affidavits and make sure Ben Newman is complying with 18001. Why is that my issue? He filed these affidavits late. He did not comply with 18001. The way that he can get those affidavits in pursuant to the statute, and we need to read the clear version of the statute, and it says, the party offering the affidavits and evidence of the party's attorney must serve the affidavit on each party to the case by the earlier of 90 days after the defendant files the answer. He did not do that. I don't need to call him and remind him to comply with the statute in order to get his affidavits in. That's not my job. We have a system in our office that calculates these things. So if he didn't file his, then there's nothing in the system to trigger me to file my counter affidavits because he didn't file them on time. So I don't really understand why this is confusing because it's in the statute. It says that you need to do it. You must do it. He must do it. He didn't do it. He didn't comply with the statute. This was his opportunity to get his affidavits in by filing them within 90 days. He didn't do that. The affidavit says that I'm allowed to file a counter affidavit pursuant to my expert deadline. And that is exactly what I did.
May I respond, Your Honor?
Nope, we're done. Let's move on to the continuance. I've heard enough. And I guess let's make sure we're all on the same page.
Sure.
I see you've got a May 5th trial date, and I'm told someone filed for a continuance. I don't know. Okay, let's see. Looks like on the 8th. And y'all both agree to go ahead and proceed on that motion today. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
And it's the defendant's motion.
Yes, and just briefly, Your Honor, we had continued the trial back in January. And one of the reasons is because of outstanding subpoenas. We have gotten mostly responses from the plaintiff's pre-accident medical providers. What they produced but specifically said that there were EMGs and MRIs that were completed 4 years and then a year before this accident. We obviously need those because this case is about whether or not there was, I guess, an injury to the plaintiff's neck or the spine. Mr. Newman did graciously reach out to the imaging provider to get me the actual reports. But we do have a medical expert, Dr. Kamal, who would like to see the films and would also like to have the EMG results. And those should have been that should have been part of the response to the subpoenas. And so because this is very specific, that involves essentially, I'm not going to try and speak with Mr. Newman, but an aggravation of a lower back issue, and we have imaging out there, we believe that it would be extremely prejudicial not to have that. Now, if Mr. Newman can do the same thing that he did with the films or with the report and contact these providers to get me these films and these EMGs that were done, then, you know, obviously we have no basis to continue the trial, but we do need these documents.
All right, Mr. Newman.
Yes, Your Honor. So the defense filed a motion for continuance back in, I think, November of last year, citing these same grounds. Like if you look at those two motions, it's almost the exact same language. What they're saying is in their motion, they don't say anything about EMGs or anything like that. They say we're waiting on records from orthopedic specialists of Austin, we're waiting on records from Longhorn, and we're waiting on records from Austin Sports Medicine. Now, as for orthopedic specialists of Austin, what they said was false. That's not true. They have those records. And to my response to the motion, I attached the completed DWQs from orthopedic specialists of Austin saying, we've given you everything we have. So that grounds that they give for a motion for continuance is false. Second, for Longhorn Imaging, they have had the findings of the report of the previous MRI reports in the body of the ProCare medical records that I produced back in February of 2024. And after reading their motion for continuance this time, I immediately reached out to Longhorn, was able to get the prior MRIs along with the business records affidavit so that they're in admissible form. And I also have since made arrangements for defense counsel to go pick up the actual films themselves. I haven't had the opportunity to tell defense counsel this yet, but those are available for her to pick up, I can say right now on the record. And now as for the EMG, I don't know when an EMG was done or if an EMG was done. I just know that subpoenas and DWQs take 21 days or so because you've got 10 days for the notice period for somebody to make an objection, and then they have 10 days to respond to the subpoena. So it's somewhere around 21 days. We are now 3.5 months past the discovery deadline. They never requested an extension of the discovery deadline. And so I don't know anything about these EMGs, but I do know that we're way outside the discovery period. Plaintiff's deposition was over 6 months ago and takes 21 days to get prior medical records. No extension has been requested, and they've had ample time to get that information. And they already have the readings from a 2017 and a 2020 MRI. They already have the notes from plaintiff's orthopedic surgeon from before the crash. I don't believe that they need anything else, and so I believe that this motion should be denied. Last thing I'll mention too is that they have been pretty grossly untimely with a lot of things in this case, and I think that's the reason why they're asking for a continuance. They have deemed admissions on file. They just responded to a written discovery that we sent out a long time ago. They just served responses on those like this past Friday. We have not objected to one subpoena or one DWQ. We've been trying to do everything we can to just get this case to trial, and we really shouldn't have to wait on their delayed efforts in getting these prior medical records, and we've assisted them every which way we can.
All right, anything else, Ms. Yamron?
I mean, if we need the EMGs, this is for the first time I'm hearing that they're able to get me the films, which I greatly appreciate. But if this is a case where they're claiming nerve damage, and EMGs were ordered 2 different times in 2017 and 2021. So, you know, if I could just get these EMGs, then I will happily withdraw my motion to continue. I would like to have them. I think it's very important to have what his nerve condition was before the accident.
All right, and you've sent a subpoena for the EMGs? When?
I sent a subpoena, we sent a subpoena back in, I believe, December. And actually, no, earlier than that. Bear with me a second.
So why don't we have the records back?
We received records, but they produced 38 pages of records. They alluded to the MRIs in that, and they, I guess, summarized the results, but the reports weren't in there. So then we asked the provider again, hey, where are the MRIs that were referred to in this report? That should be part of your medical file. The EMGs that were referred into your report, that should be part of the medical file. After I filed my motion, Ben reached out to, because obviously he's representing the plaintiff, he's entitled to those medical records. He reached out, and lo and behold, there they are. So what else is not there? They obviously had them. They referenced in them, but they didn't produce them pursuant to my subpoena. The EMGs were referenced in there twice, but those weren't produced pursuant to subpoena. I know there's probably a third party that's in there getting all the records together, and I've taken enough depositions of doctors to know that sometimes the things are in different folders. But we've been trying to get these documents for 4 months, and they finally responded like a month ago. And then we reached out, where are these documents? These are referenced in here. So if Mr. Newman, obviously he represents the plaintiff, he should be able to get me these EMGs, just like he got me the films. He got me them within 24 hours. This is something that he is in the best position to get for me, since it seems like they're not really complying with my subpoena.
May I respond for 10 seconds, Your Honor?
Sure.
Your Honor, the Texas Rules of Civil Procedure have vehicles by which Ms. Yamron can get this information. If the medical providers are not complying with a subpoena, which essentially has the effect of a court order, she can file a motion to compel and bring them to the courthouse and have Your Honor demand that they produce the records, or they face sanctions. So one. Two, in their last motion for continuance, they don't say anything about Longhorn Imaging. I haven't heard anything about Longhorn Imaging and waiting on records from them until I reviewed this motion for continuance. And I reached out to Longhorn Imaging and said, give us everything. Give us all the records that you have. I don't have any evidence that Longhorn Imaging was the one that did that EMG. And so they sent me a prior MRI report from 2017 and 2020 with a business records affidavit. And they represented to me that's everything that they have. And so I provided that to her. And I will say too that as for the other providers, Orthopedic Specialists of Austin, I know I'm going over my 10 seconds and I apologize. This is my last point. Orthopedic Specialists of Austin is a prior medical provider. They're not just going to give me his records without an authorization or something like that. So I don't have the ability to just go pluck these records from these prior medical providers, and it's not my job. It's their job to subpoena those records and to get those from those providers, and they've had ample opportunity to do so. It takes 21 days to respond to a subpoena. They sent the subpoenas way late. They didn't do anything to enforce them, and now they want to move the trial because of it.
All right. A couple of things for the record. Let me just say the continuance motion is not verified. And based on what I have heard here, I do not believe that good cause exists to grant a motion for continuance. The timetables for judicial administration of a case like this indicates that from time of filing to time of trial, 18 months is more than adequate. This case is over that. And you may or may not be familiar, but the legislature is now requiring judges to report when continuances are granted in the larger counties, and to identify and keep names of who's been given a continuance. And so there is an added level of review or scrutiny over your trial courts now about whether continuances are or aren't going to be given. But this is an old case. This is not a complicated case. And it doesn't really take 4 or 5 months to get medical records that you really should have had in advance of your last trial date, quite frankly. So you, I guess with that, the continuance is denied. I will take a little bit closer look at the Chapter 18 expert motion, and I'll get you an answer soon on that. That deposition is the 17th?
Yes, this Thursday.
Okay. Oh, this Thursday.
Yes.
All right. Well, I'll get you an answer hopefully by tomorrow then. All right.
Your Honor, would you like for my office to supplement the email where we served the 18001 affidavits 6 days late?
I think everybody agrees that it was 6 days late and that we're not here on a motion. Instead, we're here on your motion to strike her expert, both affidavits and testimony, if I'm correct.
Yes, Your Honor.
Okay. So I don't think I need that from you. I understood that to be the case.
Thank you, Your Honor.
All right. Well, I hope you've been to mediation and you know you're required to do that before you will get a jury. So just a final reminder.
Yes, Your Honor.
We got last week. We got it taken care of last week. So
okay.
Check that box.
Great. All right. Well, best of luck to you. Y'all are free to go.
Thank you, Your Honor.